Okay, hey, welcome to today's session of the PPM Attorney Capital Forum. I'm your host, Darin Mangum, securities lawyer. I'm the managing partner of Mangum & Associates. We're a international securities law firm. And I'm excited to be with you. We're going ahead and get started. We're starting a few minutes late, but I think we're good, and if there's any questions that you can share with us, we're going to try to address that at the end of the session. Welcome. Today I am excited to let me pull up our current. This is a great topic. Brokers, finders, and other money raisers. We're going to be talking about today. Let me pull up the outline. And if you don't have this outline, you should be able to get it. We can certainly, if you want to send us an email to forum@mangumlaw.net, we can send that to you. This is just kind of an overview. Now, the vast majority of our clients are, they're raising capital for amounts that are usually most of our clients are raising between maybe $1 million up to $10 million. That's probably half of our clients. The other half of our clients are raising $25 million or more. We have a client that just started a fund out of Dubai, whose their goal is to raise $1 billion, right? So I mean, that's not super common, but that definitely is doable. Like under Regulation D, there is no cap to the amount that you can raise, and so that is a feature, right? So when it comes to engaging people to help you raise capital, again, with a lot of our clients, they want to offer their investment directly to the investors without having to pay any sales commissions. They've got a direct, in some instances, when you talk about a direct offering or a direct public offering, like 506C and regulation crowdfunding, those can be sort of lumped into that category of direct public offerings. I mean, you are offering directly to the public without any sort of underwriter, without any kind of broker go-between, and oftentimes it's being offered directly by and it really should be. If there's no broker involved, then it really should be offered directly by the principals of the company, or the principals of the fund, or the general partner. Legally, those are the only people that can sell the offering without having a securities license, right? But so sometimes you don't have those relationships with the investors, and you need to my tie's a little crooked here. You need to engage a professional money raiser that is engaged directly with investors and clients. Okay, so you want to talk to a broker dealer. Now, a broker dealer obviously is someone who is registered with FINRA. Registered with the SEC, has securities licenses. A broker-dealer is a highly licensed organization and highly regulated organization. They're regulated by the SEC, they're regulated by the state in which they're operating, and they're also regulated by FINRA. Formerly known as the NASD, but it's Financial Regulatory Authority, and they otherwise known as FINRA. and they're the ones who administer the securities exams that would then, so somebody has to, if they're going to be a broker dealer, they have to be licensed at all three levels. FINRA is a self-regulatory. It's a private organization, but it's self-regulatory in the sense that it regulates its members through its own rules, and it's allows the state and the states and the SEC look to FINRA to do that self-regulation, so they don't have to, even though they themselves have authority to do so. Just another very highly regulated industry, and a lot of clients ask me, well, should I become a broker? Should I get a securities license? And that's a whole other topic for another day. But it's very much a pain in the butt, licensing, ongoing compliance, all of that to be a broker. And also to be a placement agent. What's the difference between a broker and a placement agent? I mean, a broker dealer, usually you're talking to representatives of broker dealers. The broker dealer is the firm that is registered with the SEC, and then you have registered representatives that work for the firm to help sell the offering. And then a placement agent is typically they're usually, a broker dealer, they typically have several dozens and dozens of different deals that they're selling at any given time. Placement agent is also a licensed individual. Usually a placement agent is like an individual person who is then hired to help sell one particular offering, and they may do several deals as well, but they're going to be placing, they're going to be more so focused on the specific offering that they're hired to sell. Right? They're not selling lots of different deals. Although some of them do have multiple deals in their bag ready to sell, but most of the time a placement agent is a little more focused. But in any case. And also the main difference, I mean, broker dealers, some people say, well, let's engage a broker dealer to sell our offering. And I always tell them, as a practical matter, a broker dealer is not going to give you the time of day if you're raising less than $25 million, maybe $20 million if they really like the deal, but anything lower than that is just not worth their time. They're not going to spend any time, let's say you have a $5 million real estate project that you're raising capital for. Don't bother talking to a broker dealer because they're not going to be interested. They're not going to likely they're not going to be interested. I mean, you never know. If you have a personal relationship with them and they fall in love with the deal, then certainly that's a possibility. But otherwise, I would not spend time courting broker dealers. And plus to sign a broker dealer is very much a kind of a long-term game. It's kind of like getting married. You've got to wine and dine them. You've got to meet with them several times to get them excited about your deal. And then even if they said, okay, hey, yeah, we're interested in this deal, we'd like to approve it, because bear in mind that none of the broker dealers registered representatives that are members or that have their licenses with the broker dealer, none of them can sell your offering unless they've been approved to do so by the broker dealer. And if they do sell something that's not been approved, then they could get in big trouble. They could not only get fired, but in some states it's criminal activity to sell what's called selling away. You're selling products that have not been thoroughly vetted and approved by the broker dealer, right? So registered representatives, and I see it all the time. Hey, my Merrill Lynch broker, he's super excited about my real estate deal. Can he sell it to his investors? And the answer is no, unless Merrill Lynch, which they're not going to do. the broker dealer like Merrill Lynch, they're 100% captive. They're not going to approve any sort of selling any other kind of product that hasn't been approved, or that it's not, in their case, not a Merrill Lynch product, right? They're not going to sell something else, right? So, so again, when it comes to the world of broker dealers, you've got more broker dealers that are, exclusively selling their own products, or they don't sell what we call alternative investments. When we're talking about private placements, most of them fall into the realm of alternative investments, right? And meaning that they're not. You can't just call up your Merrill Lynch broker and say, "Hey, I'd like to buy, 20 units in, XYZ real estate project." They can't. It's not a publicly traded security. It's private capital markets. So most of the things that are offered in the private capital markets, they are deemed alternative investments, right? So there are broker dealers, however, that smaller broker dealers and very niche oriented broker dealers that do participate in the private capital markets. They do participate in alternative investments like oil and gas, life settlements, crypto deals. That they're not afraid, in other words, to delve into that world. And in fact, a lot of those kind of specialize in those areas, right? Now, to get a broker dealer like that involved or on board, they need to they always do their due diligence. Usually, to get a broker dealer involved, like I said, you're going to have to wine and dine them, get them excited about the deal. It has to be a certain dollar amount, $25 million or more, for them to get excited about it, generally speaking. And then, if they just do like it, they're going to require you to go get not only to have your PPM prepared, right? And obviously, you don't want to contact a broker dealer unless your PPM is ready to go. Otherwise, they're going to say, well, we can't really evaluate it. Even if we liked what you're saying, we can't really get our arms around it because they've got to do their own due diligence. And so you need to, before you even approach them, you need to have a securities attorney draft up your PPM, get everything ready to go, so you're kind of camera ready for market, right? And then at that point, you can approach the broker dealer and say, hey, here's our deal, here's our PPM, we're all ready to go. And then at that point, if they like the deal, if they're excited about it, then you get into, and then obviously they're going to get into negotiating their commissions, which typically commission rates for broker dealers, they're typically kind of on the low end, or you're talking about 6 to 7%, and then on the higher end, close to 8 to 10% commission rate, right? So it's expensive money. It's expensive. And that's coming right off the top. As the investments come in, those commissions are being paid out, right? So, but then again, you don't have to raise the money. They've got all the relationships with the investors. So, and for some people that works. That's worth. It's just the cost of capital, right? Typically, they also require you to pay them what they would say, a managing broker dealer fee, and also due diligence fee, and maybe give them a marketing allowance. And so that sort of creeps into, instead of 7 to 8 to 10%, now you're looking at tacking on another 1% for due diligence, 2% for marketing allowance, and you can see how it just kind of creeps up to, in some cases I've seen it as high as 15%. If you look at all the fees that are going to the broker dealer for various reasons, then it's heavily, what we call a heavily promoted deal, right? There's lots of marketing expense and all that, but in some cases that's totally fine. A lot of oil and gas deals are that way, heavily promoted, and that kind of thing. So but that's but so those are kind of like what the range of fees that you're likely going to incur by paying the broker dealer, and that's on the transaction side. Even before you get there, typically they're going to ask you to do a third-party due diligence report, right? And usually there's a handful of firms that'll do a due diligence report, and basically that's kind of just a CYA procedure that they go through just so they, if the deal doesn't work out, and because they don't want to be sued, I know you have the PPM to protect you, but the broker, they're going to rely upon the due diligence report by this third party, and you get to pay for all that, right? They say, hey, you got to pay us to do this due diligence, third party due diligence report, and all of that. And so that can be pretty expensive. Not only have you incurred the expense of the PPM, getting your own securities lawyer to do all that, but now you have got to pay for a third party to give the broker dealer, and it gives them a comfort level, right? There's no guarantee that you'll get a good report, but most of the time, by the time you get into it, the whole expectation is that if you've got to that stage, then chances are you're legitimate. Chances are that you'll get a favorable report. They may, when you go through that due diligence process, they may require you to alter the PPM to some degree, especially if you're signing on the broker dealer as a managing broker dealer. Then they'll want to make sure that their fees are covered. And so not only covered, but disclosed in the PPM and all of that, right? So anyway, so that's the process of getting a broker dealer involved. And like I said, it takes a while, right? You have to, I would plan on at least, again, unless you have a pre-existing relationship with the broker dealer, that they're your buddies or your golfing buddies, then you guys, they're going to like push it through. I mean, you're planning on at least 30 days to get your PPM ready to go with your securities attorney, and then probably another 30 to 60 days to court the broker dealer, and maybe you're courting multiple broker dealers, right? Just to get them on board. A lot of this can't really even be done over the phone. You're probably going to fly to their offices, sit down with them, take them to lunch, give them a dog and pony show, blah 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 blah, right? And maybe do that a couple times to get them saying okay, to get them saying yes, I think we'll sell it. And this is way before you're even going to be an investor in the room. So you're looking about 90 days on average to get, and of course then you're getting like the due diligence report and all of that. So I always say if you're planning on engaging a broker dealer, plan on a really good really good wining and dining budget, right? To smooth them over to you're just basically trying to get them on board, right? So just like if you're dating someone, right? If you're going to have to invest some money, right? You're going to invest some time, you're going to invest some money before you get to the altar and get married with them. You're going to need to spend some time cultivating that relationship, right? So anyway, so once you do get a broker dealer to say yes, and you got the third party diligence, you'll enter into a selling agreement with them, and then at that point you would then get approval, and now you become approved product for the broker dealer representatives to sell, right? Now that doesn't automatically mean the representatives are going to be jumping up and down, ready to go, and wanting to sell your deal. All that means is now you're on the approved list. Hey, these are products that our broker dealer firm representatives can sell, and so, but that doesn't mean the broker deal, all the representatives at the different offices around the country or wherever they are just going to drop everything they're doing and now start selling your deal, right? Now now you the next stage is you get to go and wine and dine those people. They would basically go, hey, here's a list of all of our representatives. Go knock yourself out and see if you can get them all to sell it, right? Now, hopefully, you get some internal support from the broker dealer. Hey, we really like this deal. We really think you should sell it. Please give them the time of day. At least you're on the list, right? Doesn't guarantee you a meeting with them. Doesn't because each broker dealer office and in fact each broker dealer representative themselves, if they don't like the deal or they don't think their clients are going to be interested in the deal, they're just not going to get excited. They're not going to sell it, unless the broker dealer is kind of pushing them to sell it, or unless you're sort of convincing them, hey, this is why you should be selling this deal. It's a great deal for your clients, and it's great. It's a win-win, right? So, so once you get to that stage, then you might expend some additional funds, flying to Omaha, Nebraska, or Oklahoma City, or wherever these broker dealer representative offices are, and sitting down with them, taking them lunch, giving them the pitch on why they should be selling their deal. So it is a long road, right? I mean, but once you do get them involved and they see, okay, hey, this is a great product, this is great for our clients. They've got the clients that say, okay, now they're going to go and turn around and sell it. And I've had this happen with several clients where, once they've kind of gone through this whole courting, dating, marriage stage, right? Now the broker dealer representatives are out there selling the deal, promoting the deal, and at that point, they're just sort of taking checks, taking orders, right? The CEO of the company is not out there trying to beat their head against the wall, trying to raise capital. He may be fielding questions here and there from the representatives, from the broker dealer, but you see, oh, hey, John Jones, his office in Omaha brought in $100,000 this week, brought in $2 million this week, or whatever. Once you get that all going, it definitely goes rather smoothly, right? But all that machinery has to go in place, and obviously the place to start in any of this is, getting a PPM, getting a securities attorney on board to get that process going, right? So, but I mean, that sounds like a long road, right? A broker dealer, and again, unless you're raising, like I said, that certain amount, maybe you don't have the budget to wine and dine broker dealers, then that doesn't mean you're out of luck. That just means maybe the broker dealer route is something you could push off down the road once you have a track record, once you're ready to raise money at that level, right? Now, placement agents are very similar, but placement agents, as I said, they're very much they're like, oftentimes they're a one-man show, right? One-man band, as far as they're focused on selling one particular product at a time. I mean, they may have more than one. I mean, if you're selling more, if the agent is selling more than one investment product at a time, then oftentimes they may need to go and get licensed with a broker dealer, and so it's basically the same thing. But a lot of placement agents, they're they may have a securities license, but they're more kind of maybe target focused and focus on one particular deal at a time. They don't necessarily need all of the third-party due diligence and all the stuff that a broker-dealer has. They would get comfort from knowing, oh, okay, you've got a securities law firm behind you that put all this together, so that gives them confidence to go say, okay, I think we're going to go ahead and sell this deal, right? And so placement agents may be a little quicker way to get it done. But they are, you definitely want to make sure they're licensed, right? What happens if they're not licensed, right? This is a question we get all the time. I've got this, buddy, and I need to be able to sell him I need to be able to, he wants to bring me investors. Can we pay him a commission? The short answer to that is, well, if he doesn't have a securities license, you can't pay him a commission, right? But the truth remains that a lot of people use what we call finders to find investors. Finders are very much. I could probably do a whole episode just on a whole forum session on finders by itself, but finders is an area of, where the person is not licensed, but they're basically all they're doing is giving you an introduction, right? They're introducing you to a capital source, right? They're introducing you to an investor, right? And they're asking for some kind of compensation as a result, right? Now, the capital source that we've been working with lately is Marquee Equity, and they are your classic finder, right? They've got relationships with lots of different investor groups, lots of different family offices around the world, and they are, but they're not licensed, right? They're not a FINRA registered broker dealer. They're not a placement agent. They're not going to go sell your deal, but what they are what we call a finder, right? Now, the finders are, some people want to steer clear of finders because the area of the law around finders has been in flux for a long time. To give you a summary, the finder, the SEC put out a no action letter called the Paul Anka letter. Paul Anka was a hockey player that, actually he was not a hockey player, but he was a famous musician, and he was tapped to, hey, this hockey team was trying to raise capital, right? And Paul Anka had a relationship with the owners of the team, and he said, hey, look, why don't you talk to a bunch of your rich friends in Hollywood and on the music industry and wherever, and can you help us, introduce us to people, right? That was, so they basically wrote the SEC and said, hey, look, if we go and if Paul goes around and introduces investors to this company, he's not involved in any kind of selling of the company. He's just basically introducing people. Hey, here's, this is a deal you might be interested in. Feel free to talk to them. He wasn't actively selling the deal, but he would receive some kind of compensation if the people invested, right? Now, if there's no compensation, right, then there's no issue, right? The issue relates to compensation, right? How can you pay a non-licensed person if they are, in fact, a finder, right? And so the SEC basically wrote back. It's become a famous, what we call a no-action letter, saying, okay, look, if Paul, in fact, does do exactly what you say he is doing, if he just makes introductions, doesn't actively sell the deal, is not involved like a broker dealer would be in selling the deal, collecting money, distributing investment products and things of that nature, all they're doing is making an introduction, then yeah, you can pay him a finder fee, right? Just pay him a percentage of whatever, like some people call it a success fee, basically a finder's fee, right? And so for years, the people have relied upon that no action letter. The no action meaning, if you do everything like you say you're going to do, we're not going to take action against you, right? That's where the no action comes into play, right? We're not going to take action, which is always nice, right? If the SEC says, yeah, we're not going to come after you if you do this way, then okay, that gives you some confidence, right? And a lot of states have adopted no action, the Paul Anka letter allowing for finders to exist. The reason why it's a little bit of a gray area is because the SEC in recent years, they sort of flip-flopped a little bit, which is not surprising. They get some new administration, a change of the guard, and they think, oh well, you know what? I don't think we like that precedent, that Paul Anka no action precedent. I think maybe these people are not maybe should start going after people anyway, right? Because the no action letter is, even though it's good guidance, it's not binding upon the SEC. It's not legally binding upon them, right? It's just their opinion, right? And they've done that a number of times where they've decided, we're not going to. I know we said that no action letter years ago, but we kind of changed our mind, right? We're going to go after you anyway, right? So there was a court case in Florida in recent years. It's probably been maybe 4 or 5 years ago, where the SEC, decided, hey, I think these people are saying they're finders, but we think we're going to try to tag them for being an unregistered rep, an unlicensed broker-dealer, selling securities without a license. And so they went after some people that they thought that they could win. And usually the SEC doesn't lose. But in this case, the judge disagreed with them and said, no, not so fast. I don't think they're a broker-dealer. You yourself, issued this no action letter. I mean, the no action letter wasn't really determinative of the case, but it certainly had some weight because the judge decided that, hey, these people are really finders. They're really not doing things that a broker-dealer would do. And so in that case, the SEC lost, right? So it kind of got egg on its face and said, oh, okay, well, which kind of gave more confidence in the original Paul Anka letter, right? Because they're whether it's created by, this is sort of, judicial review oftentimes creates the law or defines the law and, interprets the law to say, well, you know what, I think these people are really finders. They're really not broker-dealers. And so it creates this little window that says, okay, well, maybe it's 100% legal to do so. Now, the real world is, there's tons and tons of people who engage in, making a living as finders, right? And maybe not full time, but maybe part time. But they make their living kind of bird dogging deals and introducing investors to deals, and they're kind of this intermediary where, obviously they're not licensed, they're not broker-dealers, but they serve a critical role in introducing companies to capital sources that they otherwise wouldn't have access to, right? And they typically want to be compensated to do that kind of thing. And so there's this kind of underworld, the finder underworld, right, where that is just a common occurrence, very, very common. And these finders, whether they know it or not, they're operating in this sort of not super dark gray area, but kind of a gray area where very maybe they might incur some liability, maybe not. But certainly if you're engaged in a finder, right, definitely have legal counsel on board with you, securities legal counsel specifically, to make sure that your relationship with that finder is at least within the areas that are knowable. The Paul Anka precedent, Paul Anka it would be the definite guide to drafting any kind of finder fee agreement. Make sure you've got that in writing, and make sure that the finder indemnifies you for any sort of misstatement, because what you don't want is to get involved with some bad finders, right? If you get involved with some bad broker dealers, well, and there's plenty of bad broker dealers running around, maybe saying things that aren't true, blah blah blah. All you gotta do is watch a few Wall Street movies, and you know what's going on, right? It's like, oh, just because you're licensed doesn't mean you're honest and you're all above board, right? But when finders are no different, you just want to make sure that you're dealing with some people that are reputable and that are comfortable in operating in this area, that know the rules as well as you do, right? So that's important to if you're going to engage a finder. Now, some states have gone to the extent of creating a finder exemption. Like California, Texas, they say, hey, look, you can register with us as a finder. that is something that is has some utility. Okay, make sure they're a licensed finder, but then again, the finder would have to go and be licensed in every single state where they have the investor. It's not where the finder lives; it's where the investor lives, right? And so, it's just not. It really. It's not a universal, because unless all of your investors are going to be in Texas. I mean, if all your investors are going to be in Texas, then okay, great. Get a Texas licensed finder, or all of them going to be in California. Maybe the finder can register as a finder, right? But the vast majority of finders find that the registration is sort of not very helpful to them, because it's just more. Again, it's kind of like registering as a broker-dealer. It's now they're subject to a lot of oversight and a lot of administrative rules, and so, usually, guess what? You're going to go with a licensed finder. You're going to be paying a lot more. Because they've got compliance costs to deal with, right? So, anyway, finders. I mean, it's definitely a viable way to go, but just be aware that it's not oftentimes a clear-cut path there, but we certainly have we have lots of clients that we draft finder fee agreements for. Usually the finder is maybe not a professional finder, so to speak, but they're somebody that says, hey, look, I've got a Rolodex full of I use the word Rolodex, like hopefully people know what that is. I mean, maybe I probably haven't seen a Rolodex since I don't know, 20, 30 years, but basically a list of your contacts, right? The person has a long list of contacts in their phone of potential investors, and hey, if I bring you any of these people, would you could I make a success fee, a finder fee, and so. That's certainly, you don't want to turn that away, especially if you're in a critical stage of raising capital, right? So definitely keep that as a consideration on the table. Now, when it talks about and usually, again, like we talked about compensation, I mean, finders usually charge a lot lower success fee on average, although I have seen some that are really, really high. Usually, they'll use like a Lehman Brothers formula, like 5% of the first million, 4% of the second million, 3% of the third, 4% or 2% of the fourth, and then 1% of any millions, any amount thereafter, right? That's a classic staged Lehman Brothers formula. I don't know what they call it now, but back in the day, Lehman Brothers, pre-2008 financial crisis, that's what they called it. But yeah, I mean, that's a typical finder fee schedule. But it's really negotiable. It could be all over the place, right? So, but yeah, definitely you want to get it in writing. So when you talk about other money raisers, now sometimes maybe you have a person, they're not maybe an outside placement agent, but maybe they have experience raising capital. You want to they want to be focused on raising capital. There's a way that you could possibly hire them to bring them in-house as a manager of the company. I don't know if I probably don't want to go into a whole lot of detail on this, but if the person, you could hire them, they can't just be, if you're hiring them as a manager and you're going to pay them a salary with sort of the agreement that, hey, look, if we don't raise any money, maybe we can't pay your salary, right? Then certainly that's something that is doable as well. You want to make sure that they have a written management agreement in place, that they are in fact an officer, because again, if you're raising capital without a broker-dealer, then you want to make sure the only people that are selling it are officers or directors of the company, right? So if you wanted to bring them in as, say, a VP of finance, and then give them that title and then give them that responsibility under a written management agreement, like, hey, we're going to pay you. It can't be their sole. That can't be their sole function, right? You can't just hire them and say, hey, you're just going to raise capital. That's all you're doing. You have to give them other responsibilities as well. But basically they're in house, right? They're on the team. Obviously, you have to have a high level of trust with them. They're not just a hired gun. They're with you, right? And it has to be legitimate. That way, that person, maybe they have other responsibilities as well as an officer of the company, but their primary responsibility is to talk to investors, whether they're new investors or existing investors or whatever. That's their role, right? So that way, that's something that you could structure and put somebody like that in place to raise the capital, help you. That way you can focus on your business and focus on the other things and just let them deal with the investors. Because if the CEO is doing it, it's a big time commitment. It's it distracts them from other things. And so they would, that would fall into the category, like a VP of finance would fall into the category of another money raiser person. We talked about the legal, regulatory compliance, licenses, and all of that. Best practices, make sure it's, again, have it all in writing, make sure you engage a securities attorney to write it all up. And I think, over the course of talking about these various options, I think we did address the pros and the cons. Ultimately, you've got to decide, hey, is it worth it to bring on somebody like this or to engage a broker dealer? Because there is a cost to it, right? It's not only upfront cost, but a piece of the capital. But again, if you have that skill set of talking to investors yourself, and you have the ability to bring those investors to the table yourself, then great, or if somebody on your team does that's not looking to make any money off of that, but they just happen to be well connected, and they're able to deliver these investors to you without having to pay a commission, without having to pay a finder fee, then that's great. That's the best of both worlds, right? So anyway, so yeah, as far as that hopefully gives you a good overview. I did have a few questions I wanted to get to here. John is asking, what if the broker dealer is what does it say? The broker dealer. I can't understand what he's saying there. What the broker dealer is not in the United States. Well, I mean, if a broker dealer is not if they're not licensed with FINRA, right, they're not really considered a broker dealer. They may be licensed in other jurisdictions. Like, for example, we had a client who raised a bunch of capital out of Germany, and so they had a licensed broker dealer in Germany. They were a German firm that were raising the capital, so they had to engage that German broker dealer to do that, but that doesn't really help them bring in any U.S. investors at all. It was just specifically geared to Germany. So let's see. Pete says, how can I engage a finder and pay a finder legally? I think I covered that. You definitely want a written finder fee agreement. Make sure it's written up by your securities attorney, and make sure that it definitely lists the do's and the don'ts. I mean, again, when it comes to finders, very easy for them to stray out of the white lines. You don't want, or yellow lines, whatever lines. You don't want them to cross the lines, right? They got to stay in their lane. They can't. We had problems. I had a client years ago who, they started to. Their finders started putting on seminars. Their finders started to put stuff on the internet about the deal, and all those are just no. The finder cannot do all those kind of activities. All they can really do is make introduction. Here's name and a phone number. Here's a name and an email. Here's this contact. Here's a phone number, and that's it, right? They just need to step away after that and not be engaged beyond that. Does it happen? Yeah, I mean, it happens, but you just got to be careful, 'cause, even if you have an indemnification, but, with those those finders, let's say they do some stupid things and you get in trouble for it, and, you try to get them to, hey, you got us in trouble, and then they disappear, right? You can't get them to, you can't get any, relief, right? If they sort of disappear, right? So that's, something to be aware of, right? Anyway, so yeah, hopefully this was a good session. I think hopefully gave you a good overview. Again, we're super excited to have you in the forum. If you, I was going to say like and subscribe, but if you're watching this, you're already a member of the forum. We appreciate you being a member. Again, with the forum, we try to dive. If you want, the free content, like 5-minute, hit the highlights. That's on my YouTube channel. But this forum is meant to dive deep into each of these topics. So I would encourage you to tune in to next week's forum session. I think we're going to be talking about, raising capital with using social media. We're going to be talking about that, which is a great way to do it. But obviously you've got to make sure you're doing it in compliance with the rules. So anyway, appreciate you watching. And if we didn't cover any topics that you wanted to cover, if I didn't get to everybody, please shoot us an email, or we can try to cover that in the next week's forum. And we'll see you next week. Thank you.